Hey guys, welcome to this video. My name is John Watts. I'm a consumer protection lawyer, and I want us to do a quick overview of the Fair Credit Reporting Act, the FCRA. I'm not sure exactly how long this will take. I only have 3 slides. I do have a lot of information on those slides, which I don't normally do, but I think for purposes of this presentation, it will help to be able to see this information. And so let's start off, first of all, with what are our claims against the credit bureaus? Now, the credit bureaus, we're talking about Equifax, Experian, TransUnion, and then there are 100 or 200 specialty credit bureaus. These are also known as consumer reporting agencies or credit reporting agencies. So typical abbreviation is CRA. So 2 basic claims. We have section 1681EB, which is maximum possible accuracy, and we have section 1681I, which is when you do a dispute and the credit bureau must investigate, and then it does a lousy investigation. So let's start off with this EB, maximum possible accuracy. And the basic idea here is that the law says to these credit bureaus, these credit reporting agencies, hey, guys, you need to have reasonable procedures in place to assure maximum possible accuracy. We're not looking for kind of accurate, sort of accurate, pretty accurate. We want maximum possible accuracy. So when we look at our credit report, whether it's a traditional credit report from Equifax, Experian, TransUnion, or it's a background screening report, maybe for a job or an apartment, and we see an error on there, we say, okay, is this the type of error that the credit bureau should have caught, should have never let get on my report? And if that's the case, then we may have an EB claim, maximum possible accuracy claim. Now, in the 11th Circuit, we have to have somebody pull our credit report, not us, not a consumer, but a creditor, an employer, a potential landlord. Somebody has to access our report so that there is, quote, publication. Now, not every circuit is that way. In the 11th Circuit, it's where I practice. That's Alabama, Georgia, Florida. Other circuits may not require that. If we have this claim, we do not have to do a dispute. Now, every other type of claim that we'll discuss, we have to do a dispute to the credit bureaus. This, we don't have to do that. So what are some examples? Well, we'll see this in a background screening report. So I'm applying for a job, I'm applying for an apartment or to rent a house, and they pull a background report on me, which is a credit report. Do I have any crimes? Do I have any arrests? What's going on in my background? And there is something that is just obviously not me, okay? So maybe the credit bureau reports that I am 50 years old, and then they say, and here's a crime committed by somebody who's 25. Well, that's not me, okay? Or the social security number doesn't match, and the date of birth doesn't match, and where we live doesn't match. And so there's different rules on background screening, whether we have a common name, an uncommon name. But that's an example, okay? So my employer pulls my credit report. They look at it. They don't give me the job. So I have publication. Now let's talk in a normal credit reporting agency like Equifax, Experian, TransUnion. They may have an account that shows me being 30 days late, and then the next month, 90 days late. Well, that's impossible. If I was really 30 and then I don't pay, the most I could be the next month is 60. So the credit bureau should have procedures in place to catch that, so that if the furnisher says, hey, John was 30 days late last month and now he's 90 days late the next month, they go, wait a minute, guys, this is not possible here. Or maybe I file bankruptcy and I have a Capital One account or an LVNV account, and that's included in bankruptcy, and that's being reported, but it's showing that I owe a current balance. Well, that's impossible. If it's included in bankruptcy, discharge in bankruptcy, I cannot have a balance unless I reaffirmed it, and there's a code for a reaffirmation. My point is, it's something that when we look at the report, we go, guys, seriously, you never should have allowed this to be put on my credit report. And so I'm suing you if, in the 11th Circuit, somebody has pulled my report so I have publication. Now, the more common example is that we see an error and we dispute it. And we dispute it directly to the credit bureau. So We send that dispute to them. It may be an online dispute. Well, if we're doing an online dispute, at least take screenshots, preferably do a screen record of your screen. That's what I'm doing right now. Okay, I'm recording the screen. Do that so you have proof of when you disputed, what you said when you disputed. If you do it by mail, do it by certified, or else you don't have any proof. If you send it regular mail and they never respond, how can you prove the Bureau's got it? If they don't get it, then there's no obligation for them to investigate. You might fax it. Make sure it's a working fax number. Make sure you can prove that they received it, and contact them. Make sure that they got it. Here's something else. If you just read the statute, okay, and we're doing a series, it'll take us a while to get through it, but a series where we go over every section of the FCRA. You'll notice that the way the law is worded, that if the Bureau or the furnisher cannot verify this information, it should be deleted. But most courts have said, yeah, we don't really go with that. We want to see an error. So even if they can't verify it, but it is correct and complete and not misleading, then that's okay. So as a practical matter, for most courts, we need to show that the information is actually in error. So it could be factually wrong. So it legitimately is inaccurate. They say I was late. I was never late. It could be incomplete. They're only reporting maybe the negative information about this account, none of the positive. Or it might even be accurate, but it's misleading. Okay. And my point in this video is not to do a deep dive into all that, but just say, look, we have to have an error that we dispute to the credit bureau. And then the credit bureau has an obligation to investigate. Now, part of that is they are to, unless they can fix it on their own, they are to go to the furnisher of the information. So that would be the company that furnishes or provides the information, like a credit card, a mortgage company, a debt collector, whoever it is. Go to them and say, hey, here's the dispute. But the Bureau has its own obligation to investigate. Now, this standard is a negligent standard or a wantonness, reckless standard. So the easiest way to illustrate this is to think in terms of a car wreck. Okay, so most of us watching this video will drive a car. And so here's my question. Do you have an obligation to drive your car reasonably? Well, of course, that we have to drive our car in a reasonable manner. If we're unreasonable, then that's negligence. Well, how fast can you go down your local interstate? Assume the speed limit's 70 miles an hour. How fast can you go? Well, we can't answer that without knowing the circumstances. Now, as I'm recording this, it's a beautiful day, it's clear visibility, and let's assume there's no traffic. Can you go 70? Well, sure, unless there's something unusual. But what if there is something unusual? So let me give you sort of an absurd example. There's terrible fog. It's 12 o'clock, midnight. There's ice on the roads. A school bus has just crashed, and all these kids are dazed from the crash, and they're wandering out onto the interstate, and they're right in front of you. Can you go 70 miles an hour? Well, no. You can go 1 mile an hour, or maybe you have to go 0. You have to come to a complete stop, because otherwise that would be unreasonable to just say, well, I can't see. There's ice everywhere, and I know there are children on the road. So yeah, I'm just going to fly down the road. No, you can't do that. Well, we judge the credit bureaus the same way. And we say, well, what's the danger? What's the harm? And how much information did we give them? So if they don't know that there's ice on the road and fog and kids on then they wouldn't have that obligation. But when we tell the bureau, hey, look, this is wrong. Your reporting of the payment history is wrong. The balance is wrong. The open date's wrong. The account status is wrong. You have me as an owner of the account. Really, I'm an authorized user. Whatever our dispute is, the more specific we can make it, the more detail we can give, the greater the obligation the credit bureau has to actually investigate that, and the higher standard they will be held to. Now, if they botch that, they're negligent, they're reckless, and we sue them under 1681I, normally, not always, but normally, we would also have a claim against the furnisher. So the credit card company, the auto loan company, the mortgage company, the debt collector, under what's called 1681 S2B. So let's look at that next. when we're suing the furnishers, 1681 S2B is where the action is. So, well, what about 1681 S2A? And if you read it, it is fantastic. I mean, it's beautiful. The obligations it puts on the furnishers, tells them all the stuff they have to do. Unfortunately, you can't sue them for that. So it doesn't really do us any good when we are trying to sue them. We can only sue them under 1681 S2B. So what do we need to accomplish that? We have to do a dispute to the credit bureau. And then the credit bureau, or the CRA, must forward that dispute to the furnisher. Now, either here's the full dispute, here's the 7-page letter, or maybe it's a summary. And if they don't do that, then the credit reporting agency has violated law, so we can sue them for that. But assume they've done that. And remember, the CRA, the credit bureau, has to do its own investigation. Remember, that's that idea of negligence. How broad is their duty? Well, it's based on what they know. Well, if they forward that dispute to the furnisher, now the furnisher has to do an investigation. And it's the same standard: negligence, wantonness. And again, we look at, well, how much information was provided, and what does the furnisher know in its own records that would give it the answer? So let's look at a few examples. Let's say you paid off a debt, and you paid off 6 months ago, and it's reporting that you owe a balance right now. Well, you could do a couple things with your dispute to the bureau. And by the way, you can also send a direct dispute to the furnisher. That in and of itself won't trigger any obligation to investigate. But if they get notice from the bureau, now part of the information they have to review would be your direct dispute. Okay. But however your dispute gets there, if you say, look, I don't owe this debt. Well, if that's all you say, that's probably not enough for the credit bureau to know that this is false information. So their duty to investigate would be very narrow under most circumstances. How about for the furnisher? Well, if you say you don't owe it, see, the bureau can't just pull up its records and check and see how much you owe. But the furnisher sure can do that. And if they know that you paid it off 6 months ago and you say, look, I don't owe this, then they've got to do a proper investigation, which is, hey, let me look at my record. Oh, hey, look, it was paid off. So let's correct the credit reporting. If they don't, then you would have the ability to sue. Now, you might give more detail with your dispute to the credit bureau. You might say, here's a canceled check, and here's an account statement right before I pay it off. Here's an account statement right after I pay it off. You see, I owe zero. And that could then put potential liability on the part of the bureau and the furnisher. So sometimes we're suing just the bureau. Sometimes we're suing just the furnisher. Oftentimes we're suing both. Okay, so let's go through another example. Your debt was included in discharge and bankruptcy. Well, you might do this full-blown dispute where you say, here's a copy of my petition, here's where Capital One or LVMV was listed, and here's my discharge order. I did not reaffirm the debt. Well, now that's obligation on the bureau and the furnisher. Or you might just say, hey, this account was included in bankruptcy. Okay, and the bureau knows your bankruptcy court number. They can look this information up. That may or may not be enough to put liability on the bureau, but it certainly puts liability on the furnisher if they don't fix it because they know it was included in bankruptcy. How about you paid it off last year, and as I'm recording this November 2020, it's reporting as 120 days late in November 2020, and you paid it off last year. That's impossible, okay? So that would take us back to our EB claim, right? The bureau knows because the reporting says it was paid off in October of last year, but now it's being reported as late November of this year. That's absurd. They know that that's wrong. So you dispute it. Hey, I don't owe anything. So that would be an I claim against the bureau, but also against the furnisher. Okay. I'm not late in 2020. I can't be late because I paid it off in 2019, whatever it is. So the idea is we decide when we do a dispute how little or how much information to provide, and that's going to dictate who would be liable, whether it's just the bureau, just the furnisher, or both. Now, if we have a claim, so an EB claim, an I claim, an S2B claim, what are our damages? Well, we have a couple of types of damages. We have actual damages or compensatory damages. And that's the idea, to compensate, to bring you back to where you were before the bad stuff happened. So think in a car wreck, somebody hits you, your legs are broken, you're off work a bunch of time, so you have lost wages, you have medical bills, and maybe you have a permanent impairment, you certainly have pain and anguish. And so we have to put a dollar value on that to say, let's get you back to compensate you where you were right before the wreck. Same thing here. You might have a higher interest rate because of false credit reporting. So instead of getting 3%, you got 6%. Well, we take what's the difference in payments. We go out over the life of the loan, 30 years for a mortgage, and then we reduce it to present value because that gives us the accurate amount. Maybe we lost our job. We lost a security clearance. We didn't get a promotion because of false information on our credit report. That would be economic damages. How about emotional distress? When we have false stuff on our credit report, whether the bureaus would say, oh, that's little. Well, if it's little, why do you report it on me? But whether it's, quote, little or big, any false information on a credit report is naturally going to cause us to have emotional distress. So we as consumers can testify about that, but it's better if we can also have others testify. What do they observe about us? Now, if we happen to mention it to our doctor, most of us don't do that, but some of us will. Maybe we have a therapist, a counselor, general practice doctor, and we mention it to them. Well, then that can be helpful. If we have physical symptoms or manifestations of this. So, my heart's pounding, my stomach is all knotted up, I wake up, it's affecting my sleep, whatever those physical things are, that can help. Now, I will say this without getting too far in the weeds. For most Fair Credit Reporting Act claims, we see the bad stuff, we dispute it, they don't fix it. It's from that point going forward that we have damages. Okay. Now, sometimes we can reach back. Maybe it's an EB claim, but generally, let me give you a normal scenario. You get turned down for a mortgage loan. You're like, what in the world? And you see this just really bad information on there that's incorrect. So you dispute it. They don't fix it. Well, we may not be able to get the damages for that turn down. We may need to apply again because maybe we can get through. Maybe we can get that loan. And if we cannot get that loan, now we have, sort of picture this on a timeline, the false information, and then we dispute it, they don't fix it, and then we have a credit turned down, or we don't get that promotion or whatever it may be. And we can talk about that in other videos, but just understand there's a few quirks with damages as far as when you start calculating damages. Now, we also have statutory damages. This is different than the FDCPA, the Fair Debt Collection Practices Act. Statutory damages and punitive damages we only get if it's intentional or reckless or wanton. This is more than just being negligent. This is where they're just acting in disregard of our rights. So again, think about driving on the interstate. Being careless is negligent, but if we see traffic stopped and we're like, I don't care, I'm going to wait till the very last moment to slam on my brakes. Or, hey, I don't have very good visibility. I'm going to keep on driving because I don't want to be late. Well, that's reckless. Driving while we're drunk would be reckless, okay? And so the bureaus, particularly if we dispute multiple times, but also it could be one time where it's just absolutely clear that this is wrong. And they go, we don't care. We're just going to keep it on your report. It's up to $1,000 per violation, and you can stack those violations. FDCPA, we cannot stack them. We get one up to $1,000 maximum per defendant per case. But here, we might have Equifax violating law 27 times. Hey, that could be $27,000. We have punitive damages. Again, only if intentional, reckless, or wanton. And that's to punish this company for doing this and to deter them from ever doing it again, or any other company from doing this again. And then we get attorney's fees and cost of litigation. This is so that when you sue under the Fair Credit Reporting Act, your lawyer will not say to you, hey, I'm going to need $10,000 to get started, probably another $50,000, $100,000. No, that's not how we do it. We get our money from the bad guys or out of the settlement. And so what this does, this puts you on at least equal footing with these 2, 3, 4, 500 person law firms that they have unlimited money. Well, if you get a lawyer who knows what he or she is doing, they can go toe to toe with these guys. I think we're in a better position because we actually like what we're doing. I think most of the lawyers that defend these companies, they don't really wake up in the morning and go, oh, I'm so excited I get to defend some crooked company. No, but when we represent consumers and we know there's false information, we know this has harmed our consumer, that gets you fired up in the morning. And so I think that we are in a better position as lawyers to go after these companies. But look, this is the overview. I'm not sure how quick this was, but in any event, hopefully this gives you a nice overview of the Fair Credit Reporting Act, and we'll continue to do videos on this. If you like it, feel free to click like. If you haven't subscribed and you like this sort of video, hey, we put out new videos every day. Love for you to be a part of our group and be able to watch these videos, comment on these videos. If you think somebody might enjoy this, maybe they need this, feel free to share it with them. And I appreciate you guys watching this, and I'll catch you in the next video. Okay, have a good one. Bye-bye.